Hello, and welcome to the Ministry of Government Relations four-part webinar series on development appeals. This series provides important information on development appeal processes and procedures. This video is part 3 of the series and provides information on conducting an appeal hearing. The content of this webinar series is based on the Development Appeals Board Guide on Saskatchewan.ca. This guide includes several samples, checklists, and flowcharts to help make the development appeals process as simple as possible. To access the guide, search Development Appeals Board Guide on Saskatchewan.ca. In this webinar, we will examine the conduct of the board during an appeal hearing, challenges to the board's jurisdiction, appeal hearing procedures, presentation of evidence, and rules of exclusion of evidence. Development Appeals Board members are expected to conduct themselves in accordance with the board's guiding principles. The board members should be mindful that their conduct during the hearing can influence the behavior of the parties, as well as the perception of fairness. The board must give all parties a fair hearing and consider all submissions in an impartial manner. If a board member has a real or perceived conflict of interest, it is important that the member declare conflict of interest at the beginning of the meeting and leave the hearing immediately. Any member with a conflict should refrain from discussing the matter with any party, including other board members. Occasionally, the board may be challenged on its jurisdiction to hear an appeal. Some of the challenges that may be claimed include inadequate or insufficient notice of the hearing. This claim alleges that the minimum public notice requirements in the Act were not met prior to the hearing. Failure to comply with any applicable legislation. This is a claim that legislation was not followed in the appeal procedure. For example, if the appeal documents were not publicly available prior to the hearing. Failure to comply with a procedural order. If the appeal is occurring as a result of a court order, this claim alleges that any procedures as part of the order were not followed. Alleged bias. This claim alleges that one of the board members may have a conflict of interest and, therefore, may be biased, or that the board is inclined to be biased on a number of factors. For example, living in an area nearby to the property subject to the appeal. The appeal is beyond the board to decide. This claim is that the subject matter being heard by the board is not one of the eligible items that the board has jurisdiction over, such as the types of appeal outlined in Webinar 2. Finally, a party has applied to a court to stop proceedings. If one of the parties has taken the matter to the courts, they may claim that the board should not hear the appeal. If the jurisdiction of the board has been challenged, the board may respond in one of two ways. The first, they may immediately excuse themselves, discuss the matter, and draft a decision to be read into the record. The decision must include the outcome and the reasoning. If the board agrees with the claim that they do not have jurisdiction, the board's decision may be that they cannot hear the appeal, and the appellant may appeal to the Saskatchewan Municipal Board. Second, a board may decide to make a decision on the challenge at a later time and proceed with the hearing. This permits full consideration of the issue being challenged and careful preparation of the decision. However, it may not be practical for a board to reserve its decision in all cases, especially where the issue being challenged is central to the appeal. Understanding the board's procedures and jurisdiction fully is the easiest way to prevent challenges. A Development Appeals Board hearing should be a formal process with structured proceedings that provides confidence to the public in the process. The chairperson oversees the hearing, is responsible for maintaining order, and ensure that the hearing flows efficiently through the process. The following slides will examine each of these steps in more detail. At the opening of the hearing, the chairperson should ask if there are any concerns respecting the adequacy of the public notice. This should be done as early as possible in case of a problem with the notice that may require rescheduling of the hearing. In the opening remarks, the chairperson should also introduce themselves and the board, introduce the subject of the hearing and the relief being sought, note the statutory authority of the board. For example, the chairperson may say something like, "The Development Appeals Board acts under the authority of the Planning and Development Act, 2007. Set out the purpose and procedures of the board, outline the basic rules of conduct for the hearing. For example, these rules may include addressing the panel rather than other parties directly, allowing one person to speak at a time, and turning off cell phones. Ask the appellant and the respondent, municipality or the approving authority, to introduce themselves and any representatives. Lastly, The chairperson will briefly review the documents received to date, and if there are no objections from either party, the documents will be marked as official exhibits. Following the introduction of all representatives and appellants, the chairperson will ask the appellant and respondent to take an affirmation. Affirmations can be simple and may include wording such as, "Do you solemnly affirm that the evidence you are about to give in this matter is the whole truth and nothing but the truth?" All evidence presented must be relevant to the appeal and either support or refute the reason for the appeal. Before a hearing, the board should clearly determine what has to be proven. This will assist in making decisions on what evidence is relevant and, therefore, admissible. As a general guide, evidence should be adequate or sufficient to support the appeal, relevant to the grounds of the appeal, reliable, and admissible, and not subject to any rules of exclusions. The rules of exclusion disqualify evidence if it compromises the protection of confidential relationships, is illegally obtained, involves settlement discussions or off-the-record discussions, compromises a statutory privilege, is based on hearsay, or is an opinion. Opinion evidence is based on what the appellant or witness thinks, believes, or infers from the facts of the appeal. It is not usually evidence the witness saw firsthand and is generally considered unreliable and therefore inadmissible. Where any party or anyone served with a notice wishes to call an expert witness, they will need to qualify the expert before the board will grant the person expert witness status. This occurs at the beginning of the witness's testimony. The party calling the witness will ask the witness to testify about his or her area of expertise and then ask the board to accept the witness as an expert in their field. The other party will also have an opportunity to cross-examine the witness on his or her experience. If there are no objections, the witness is accepted as an expert. If there are objections, the chairperson will outline the objections and provide an opportunity for both parties to give arguments. The board must then decide whether or not to accept the witness as an expert. Experts generally give opinion evidence or factual evidence. If providing an opinion, the expert is presented with a hypothetical question with some assumptions, and they give their opinion of the outcome. The board must give weight to the opinion evidence given by the expert witness when applying the evidence to their decision making. Factual evidence may also be given based on the expert's knowledge of the facts and their opinion on how they affect or influence the appeal. Upon completion of the affirmations, the appellant proceeds to begin their case with an opening statement. Opening statements for either the appellant or respondent should set the stage for their evidence and any witnesses that they will call. After opening statements, the appellant or respondent may proceed with presenting their evidence in support of their position. This could include documents such as maps, policies or regulations, photographs and videos, and expert opinions in the form of a testimony or report. Each party may then call their respective witnesses to give testimony regarding the matter. Their expert testimony forms part of evidence for the appeal. When all evidence has been presented, the party will provide the board with a summary of their evidence. The appellant presents a summary following their case, followed by the respondent's case and their summary. The appellant may present a rebuttal summary if the respondent has raised an issue not previously mentioned by the appellant. Following the summary of arguments, the chairperson will ask both parties if they have additional questions of the other party. If both parties have no questions, the chairperson will provide closing remarks, such as when and how each party can expect to receive the board's decision. This concludes our third webinar in the Development Appeals series. To learn more about the Development Appeals process, view our other videos in this series, as shown on the screen. If you have any questions related to the Development Appeals process, please contact the Community Planning Branch for assistance. The branch also offers in-person development appeal workshops that explore this content in more detail. Please contact the branch and arrange a workshop in your area. Thanks for watching.